Good afternoon, everyone. This is Attorney Elise Gross. Today we're going to be speaking about estate planning for your parents. It's actually a topic that's very near and dear to me, and for those of you who have parents who are getting older and are finding that there's certain responsibilities that might be falling upon you, or whether it's your grandparents, it's very important to pay attention today because there's some things that I'm going to talk about that will be relevant to that situation as well as potentially relevant to you and what you can do for your own children on a later date. We're going to be talking about basically what estate planning is. We'll be dealing with the different incapacity documents. We'll touch upon long-term care, Medicaid, funerals and burials, and everything else in between. Estate planning is really just the basic way of how you position your assets to leave them upon your death and how to take care of yourself during incapacity. It's naming people who are going to take care of you. It's naming people who are going to take care of your assets upon your death. Who's going to take care of the assets on behalf of the children? How are the children or other heirs going to get it? And obviously, you want to do things in such a way that's the most tax efficient and the best way to protect yourself, if at all, or the beneficiaries from their creditors. When we talk about incapacity planning, which is the first phase of estate planning, what happens if you become incapacitated? If you're no longer able to handle your own affairs, who's going to handle things for you? That's the first stage of what we're going to be talking about today. And we're going to be talking about all the different documents that are involved there that your parents and your grandparents should have in place so that it makes it a lot more efficient and easier for you to be able to take care of things for them. And what I did is I separated things out into two categories. There's the financial end of it, and then there's the physical and the healthcare end of it. So we're going to go into each document separately and talk about where they fit in terms of the things that you're going to need to take care of. So the first one, and probably arguably the most important, is the power of attorney. Now there's different types of powers of attorney. Power of attorney can be separated into two different types of categories. One is a general versus a specific or limited power of attorney. And the difference there is that a general power of attorney, which is the more common, is a very broad document. It pretty much gives the person you're naming, who we call the agent, the ability to do almost anything that the principal, the person giving the power, is able to do. So if it's your parent giving you as the agent a general power of attorney, you'll be able to step into their shoes. This is only while they're alive, and be able to handle any sort of financial matters for them, whether it's opening a bank account, filing tax returns, signing investment forms, signing for real estate, anything that they could do, you can pretty much do. That would be a general power of attorney. Where we use the specific or limited power of attorney would not really be in terms of an estate planning event. It's more of a specific type of situation. Is somebody going out of town? Let's say your parents are going on a long vacation and they need to close on their house, but they're not going to be around. Well, they might give you a specific or limited power of attorney to have the ability to sign those specific documents on the sale or purchase of a home. But that doesn't usually last for a long period of time. It's only for that specific event for a specific period of time. That's not long-term planning. That's more just a simple business thing that needs to be handled and isn't something that lasts for a very long time. Whereas the general power of attorney is a broader spectrum. It's giving broad powers. Once you separate between general and specific, then we can separate it between durable and non-durable. A non-durable power of attorney is one that is only good as long as the principal, the person creating the power of attorney, has capacity. The minute they become incapacitated, that non-durable power of attorney no longer has any effect, which, if you think about it, is really not the purpose for most powers of attorney. Most people create the power of attorney so that they have somebody in line in the event that they become incapacitated to be able to handle things for them. That type of power of attorney is a durable power of attorney. It's one that, just given the word durable, it lasts. It goes beyond incapacity. It has language in it that says that the power of attorney will continue to be in effect despite incapacity of the principal. So the more common is the durable general power of attorney. That's what you're going to be seeing when you're talking about doing something for estate planning purposes. You might consider using a non-durable power of attorney, general or specific, if, let's say, you have a business partner and you want them to be able to do certain things while you're capable of overseeing them, but you wouldn't want them to necessarily have the power beyond your incapacity. So the durable general power of attorney is what we use for incapacity planning. That's what your parents should have. Now, what they'll probably have is naming each other as the agent first, meaning the parents name each other if they're married, and then they're going to have a successor, one or more successors, and that's where you're going to come in. That's where you or your siblings are going to be named as the agents under the power of attorney. Now, they may name one of you, they may name multiple agents. From a practicality standpoint, it generally makes sense not to have multiple agents under a power of attorney, just because if you do, then it's a question of whether or not both of you, or however many there are, need to sign each and every document for each and every transaction. Now, you can structure it that it's an or, meaning that either one of the agents would have the full power. It's just a personal decision from the person creating the power of attorney how they want things handled and who they trust, and if they want there to be a joint power or if they want there to be individual powers. With that said, your power of attorney is only as good as the financial institution or recipient who is honoring it. So you have to be very cognizant of the fact that sometimes you're going to get some pushback when you try to use a power of attorney, whether it's from a bank or from a lawyer or from anyone else that you're presenting it to. You may get some pushback. So when we draft documents, we have to keep that in mind, which is why we always say keep the original power of attorney. It's one of the few documents that you may need to present an original. In fact, it's probably not a bad idea when you're executing a power of attorney to execute multiple originals so that in case one gets lost, you're able to have a backup. And if you don't, then just make sure that if you're presenting an original that you always get it back. And for the most part, anyone you're presenting it to, whether it's a bank or anyone else, they're going to ask to see the original, but then they'll make a copy of it and write down that they've seen the original, and that's all they need. They don't need to keep the original. So you should always be able to get the original back. So that's your durable general power of attorney. And that is going to be probably the most important document that you're going to have, because that's going to allow you to do things that will allow you to take care of the parents' or grandparents' financial needs in the event that they're incapacitated. It's going to allow you to pay for help for them, whether it's in a nursing home or outside of a nursing home. It's going to allow you to pay their bills and take that off their plate. It's going to give you a lot of flexibility, and hopefully, between the power of attorney and the other documents that we're going to be discussing today, you're going to be able to avoid having to declare the parent incapacitated and get a guardianship going for them. And we're going to talk about guardianship briefly when we get to the Declaration of Pre-Need Guardian, and you'll see why it's so important to have all the other documents to try to avoid that guardianship. The next document that I like to do is called the HIPAA. I do it as a HIPAA release, and everybody probably knows what HIPAA is all about. It's a way of protecting your privacy, and you've signed countless paperwork with doctors and other institutions where you've waived HIPAA rights or appointed somebody to be your HIPAA personal representative. This language, I do it as a separate document, but it also gets inserted, the language, into the power of attorney and then the healthcare surrogate, so that it enables whomever you're naming in these documents to be able to get whatever information they need in order to best help you. So for instance, it's in the power of attorney. Well, if you didn't have any sort of HIPAA power in the power of attorney, your agent might not be able to handle your medical bills for you because they wouldn't be able to get your explanations of benefits or any insurance records or any information from the doctors to be able to pay those bills for you. If HIPAA is so universal now, it's in the educational arena as well. It's in financial, health, education. It's all over the place. So we always make sure to put the HIPAA information in both the power of attorney and the healthcare surrogate document. And then over and above that, we do another separate release that names anyone who's going to have any powers within your estate planning. So it'll name the agent under the power of attorney, the surrogate under the healthcare surrogate, the trustee, the personal representative or executor under your will. So I like to just kind of go a little bit over and above on this one. That way there's one document that names all those people and gives them the ability to get this information. Now, keep in mind that if you have this document and it's presented, then the people you've named do have the ability to get your medical and private information. So you want to be very careful. You know, ultimately it's going to be you who are going to be handling this for the parents or grandparents, so you're going to want that document. But from their perspective, they don't necessarily have to give you these documents today. What they should do is tell you where they keep it. That way they can feel secure that you're not able to do anything right now. And that's just always been an issue that comes up when I do planning for people. They want to know, what do they do with these documents? Who do they give them to? What if I give them the documents now? What are they able to do? And the reality of the situation is, depending on how you structure your documents, is whether or not your parents are giving you the abilities today. Are they giving you the ability to take their money and open a bank account as power of attorney, to sign documents for them, to make healthcare decisions for them, to get their private information? That's a possibility that they are giving you that power. If they don't want you to really have the power today to be able to exercise on that, then they're going to keep a hold of those documents and just tell you where to find them. So from your perspective, if you want to assure your parents, then tell them they don't need to give you copies of the documents today. They just need to make sure you know where to find them in the event that they're needed. The pre-need nomination of guardian. So I mentioned before about guardianship, and I mentioned that it's important to try to avoid it. So what is guardianship? Guardianship is a court process that declares a person incapacitated by law and appoints someone or multiple people to be their guardians, to take care of their needs under the supervision of the court. So right now we're talking about the financial end of things. So we would have a guardian of the property who is in charge of any money that you would be receiving as an individual or any assets that you own individually. Let me contrast that with assets that are held in trust, because assets that are held in trust would be governed by the trustee and wouldn't necessarily be controlled by the guardian, and that's a good thing. The guardian, once appointed by the court, and it's a process, they have to go through a vetting process, a criminal background check. I believe they have to do a credit background check. They have to submit fingerprints. And then there's a whole process in which the court, before you even get to a court hearing, to declare you incapacitated. There's a whole litany of specialists who have to interview the potential incapacitated person. There's usually a social worker, a psychologist. It depends on what state you're in as to who is on this committee, but there's a committee. They don't just drag somebody into court and say, okay, you're incapacitated. There's a due process that has to be followed, and that's a good thing because obviously you don't want somebody to be able to be declared incapacitated when they're not. So the rights of the potential incapacitated person are protected, and there's a committee that forms and interviews and does reports along with everything that's being done to vet out the guardian. And only then, if the person is declared incapacitated, do you become the guardian. If you have to become a guardian, that's because you've done everything you can to avoid it, and now this is your last resort. The court is going to require reports to be filed each and every year of any money that is spent from the ward's money, from the incapacitated person's money, and any money that is received. So income and disbursements are put in a report and submitted to the court every year. It's not a cheap process. The beginning of the guardianship to get somebody appointed is usually fairly expensive. And then every year you have to pay an attorney to submit your annual report. So keep that in mind. That's one of the reasons we like the other documents, because sometimes, most times actually, if you do all the other documents and everything is structured properly, you can avoid a guardianship even if somebody becomes incapacitated. And that saves their dignity. They're not going to be declared incapacitated by a court of law. The other type of guardianship, which is very important, is not necessarily going to be that relevant for your parents, but I'm throwing that in there, because I think everyone who's listening today is not just listening for a parent or a grandparent, they're listening for themselves as well, and this will apply. What we don't realize is if we have young children and we become incapacitated, we're not dead, so our will hasn't kicked in yet, but who's going to raise our children? Who's going to take care of our children? So it's important from a minor standpoint to have a pre-need nomination of guardian document with regard to your own minor children, so that if something happens to you but you're still alive, someone can step in and take care of the children, manage both money as well as their care and custody. Also on the financial end, let's end with a trust. And there's two different types of trusts you can create. One is a revocable and one is an irrevocable. The revocable trust, which is the most common, is basically your own money. You keep control of it. So if your parents are creating this, they're keeping control of it while they're able to. They can use the trust to structure tax beneficial inheritance for when they pass, both for their surviving spouse and for their children or any other heirs that they want to include. But while they're alive and have capacity, they can control the money. It doesn't take it out of their taxable estate. It's still theirs in terms of an estate or inheritance tax when they die. But by owning assets in a revocable trust, then they can avoid the probate process on those assets. And for those who don't know, probate is kind of the mirror process to guardianship, except that it happens after a person dies. And any asset that's owned by an individual in their individual name, that's not in a trust, that's not owned with a right of survivorship with somebody else, or doesn't have a living designated beneficiary, is going to go through probate. So if you're using the trust properly, the assets will avoid probate. If you create the trust and don't fund it, your assets do not avoid probate. And that's a very common misconception. You must fund the trust. The irrevocable trust is a trust that once created, the person who creates it loses control over the assets. They're essentially giving it up. There are tax reasons, there are creditor protection reasons to doing an irrevocable trust, but it's kind of beyond the scope of what we really need today, because unless the older generation has such a sizable estate that there's going to be an estate tax issue, which as of today is basically husband and wife have about $22 million they can give away without there being an estate tax, then an irrevocable trust is not necessarily something that's going to be on the plate. Doesn't mean it's never there, but it's not going to be your more common planning. The revocable trust is going to be the more common. Now, mom and dad might have separate trusts, or they may have one joint trust. It's really a planner's decision along with the client when they sit down to discuss what the assets are, how the assets are owned, what they want to ultimately accomplish after their deaths. So it could go either way. It could be joint or it could be individual. But again, the key is if you have to fund the trust. You have to put the money and the assets in the trust for it really to give you the biggest bang. If you don't fund the trust, then the assets are going to have to go through probate, but will ultimately end up in the trust. And that's a good thing, because it's the trust where all of the provisions of where money's going to go, how it's going to go, how often, who's going to be in charge, all that is going to be built into this trust document. So if you funded everything while the parents are alive, then it's going to avoid probate, and the assets will just much easier pass to the next generation or in trust for the next generation. If you have to probate, then you'll have to go through the probate process. It'll ultimately end up in the same place in the trust. But that's where we put all the work if they're creating this trust, because the trust is going to give the most flexibility of how the assets are going to pass after the older generation passes. When you sit down with your parents and discuss what type of planning they've done, it's a good idea to bring up a trust. And I'm going to tell you that not everybody needs one, and not everybody should be sold on one. There are some times where it's just really not necessary. And there are some jurisdictions, like New York, New Jersey, a lot of the East Coast states, where revocable trusts are really not the most common way of planning. There, because probate is not as difficult, they may do a will, and in the will, they'll create a testamentary trust. So the will might be 50, 60 pages long, but it'll contain the same trust that you might have done if you were, let's say, in Florida during your lifetime. So you can accomplish it both ways. It's just a question of, do you want to go through probate or you don't want to go through probate? The other caveat I'm going to tell you about a revocable trust versus doing a will with a trust is that aside from probate, you've got an issue of incapacity. If your parent becomes incapacitated and they haven't created a revocable trust, then you're going to have to rely upon the power of attorney and the healthcare surrogate in order to get everything accomplished. And it may not be enough to get everything that you need done. So the trust is an extra way of planning for incapacity. But again, it's going to depend on what state you live in as to whether or not that's a common practice. But it's definitely worth a conversation with the estate planning attorney in whatever state the parents are living in. Now I want to switch gears over to healthcare. So we've talked about what happens with the assets with money while your parents are alive and you might need to take care of them. You'd be using that durable power of attorney. You might be subject to the declaration of pre-need guardian if you can't avoid a guardianship, and you can use the trust. But on the health end, what happens if your parents can't make medical decisions, if they're just beyond the capability of making a decision? That's where the healthcare surrogate kicks in. That's when somebody is being appointed to be able to make medical decisions. And when I sit down with my clients, we talk about who the right person is. It's not necessarily the oldest child. It may not even be the spouse. It's the person that can think clearly, in a difficult situation and be able to communicate with medical people, but they don't have to have medical knowledge, but they have to have an ability to understand what they're being told so that they can make an educated and informed decision on behalf of the person that needs it. And that might be things like surgery, making life or death decisions. So it's something that's very serious, and it has to be somebody who is not going to be overly emotional just because they have to be able to make decisions and not necessarily at an opportune time. So when we sit down to discuss who the right person is, I give them those parameters and they make decisions, and it's essential across the board, no matter what document you're doing, that you consider not just the primary person you're naming, but also the alternatives. What happens if the first person can't do it? Whether they're deceased or just unable or maybe even unwilling, have the backups. Because remember, once a person is incapacitated, they can't execute these documents anymore. So you want to make sure to cover all the bases. So when your parents are sitting down and doing this planning, make sure that they know that they don't want to just stop at the first line. They want to go down as far as they can think, because there's no downside to naming successors. There's only a good. With regard to naming multiple people at the same time as your healthcare surrogate, I'm not a huge fan. Some jurisdictions don't even allow it. But if you think about it, if you name multiple people, if there's a disagreement, the doctors are not going to know who to listen to, and it's going to become a huge problem, and it could cause a time delay, which could delay proper care. So I generally recommend that it's one person at a time. They can consult with others, and it's important that they be told that they should consult with others, but they shouldn't have to be required to have that person participate in the decision making. The living will is also another important document. And believe it or not, the living will is more important for you as the next generation, for the person who has to actually deal with these things when the parent is no longer able to make decisions. And this is why it's important. The living will is the document that says that, if the person is in a situation where they can no longer communicate, and the doctors have basically said there's no hope of proper recovery, it's a declaration that the person does not want extra measures taken to keep them alive artificially. So it might be that they're in a coma, they're in a vegetative state, but they have cancer. Should they be given radiation or chemotherapy? Most people would probably say no. But the living will gives the person who creates it the ability to say what they would want done, so that when you, as the ultimate decision makers, have to make these decisions, you don't have to think, what would they have done? Oh my God, am I going to kill them if I say pull the plug? Am I the one making that decision? It's a very good way of expressing desires, and you can be very specific. Most of the living wills are standard documents, but I've done some for clients where they've put many, many different scenarios into the living will because they want to give as much guidance as possible to the next generation. Because the last thing you want to do is be in a position where all of a sudden, God forbid, your parent is in a coma, they're in a vegetative state, and you have to make a decision and have no idea what they would have wanted. So while it may be a morbid conversation, it's a very important conversation for families to have. You should always know what your parents are thinking. What would they do in that situation if they were able to make the decision? Because that's going to take a lot of the burden away from you from having to make that decision off the cuff without having any knowledge of what they would do. There's been a lot of case law on this, and it goes back and forth as to who should make those decisions if somebody is incapable of doing it, and what would that person have wanted. You don't want there to be speculation. You want there to be some concrete evidence that this is what my parent would have wanted, because if you're the one having to tell the doctors in the hospital, you don't want it on your conscience that, you're making a decision having, against what they would have wanted. There's also some religious considerations that you need to be aware of with the living will. Depending on what religion your parents are and how heavily they practice, they want to weigh that into the consideration when they do a living will. Most of the time, people don't put the religious considerations in there. I always bring it up because I think it's important for them to know they have an option to include those in it. And if they don't, that's fine. But it's important that they explore that option before they actually create the living will. Once you have all of these documents in place, I think you're in pretty good shape, because now you'll have the capability of being able to handle certain things for your parents, which is great. Now, you're only able to deal with the cards that you're given. So great, you have all these documents, but what are their assets? Do they have enough to sustain them if they live long lives and have to go into a nursing home or need home care? That's where things like insurance comes in. Whether it's a life insurance policy that has a long-term care rider, or whether it's a life insurance policy that has cash value that they can borrow against, or you as the agent under the power of attorney can borrow against to pay for their care. These are all things that have to be considered as the financial end of the planning. Because otherwise, if they can't afford their care, then it's going to have to come out of your pocket, or they're going to have to apply for Medicaid, which we'll discuss in a moment. But some of the things that they can do to reduce the burden on both themselves and on you are long-term care insurance, life insurance with a whole life insurance that you can borrow against, maybe disability insurance if they become disabled during the years that they're working, Social Security disability, depending on when it is they become disabled. I'm going to touch a few minutes on long-term care insurance. I don't know tremendous amounts about it. I don't sell insurance. I just know that, having experienced for myself, a long-term care insurance policy can be very helpful, whether for a short-term or a long-term, if a parent becomes incapacitated or if they just need additional help at home. If they need some extra care and it's too difficult for your other parent to take care of them because of age or physical inabilities, a long-term care policy can really be very helpful. People are living a lot longer, and the chance of somebody ending up in the nursing home or needing home care are very, very high, and the costs are huge. So if you have a long-term care policy, I don't know of a single policy that will cover the entire cost, but it's going to help defray the cost, which means it's going to help minimize it either from their end, not to deplete their assets, or from your end if you're picking up the tab. So having a good policy will be helpful. Now, the policies are only as good as what you buy. So there are many, many different types of policies, and there are different coverages that you can get. They usually go in terms of how much of a benefit do you get on a daily basis, or how long the benefit will last, how many months, years, etc. And it's only really good if you get it when you're young, so you're paying, not necessarily young, but maybe in your 50s, so that you're paying for it. You may not need it for a while, but you're able to qualify at a lower rate because you're younger and healthier. So I've been told that the time to really look at it is, in your 50s, because that's when you're going to get the best rates. And we're probably all going to live a very long time. So ultimately, we will probably end up needing care. And therefore, it's a good idea to kind of look at it. The things you should be looking at, though, with your long-term care policies, you should be looking at how long the benefit is going to last, how much of a per-day benefit it's going to be. If you use the benefit, do you have the ability to get the benefit again if you don't use all of the benefit for that one illness? And something that I discovered that might be the case, which you should definitely look into, is whether or not any of those benefits are income taxable to the recipient. That just came up recently. So definitely you want to look into that before you start taking long-term care benefits and find out if it's going to be taxable to you. Because if you think about it, you're not actually receiving money. The money is going to a caregiver or to a nursing home, but you may actually have some income tax on it. That may not be the worst thing in the world because it balances out with the fact that you have the policy, but you want to be aware of it. Obviously, the older you get, the higher the premiums are going to be. Your health will hopefully be good for a very long time, but at some point, it might not, age is going to win out and your health is going to suffer, and therefore you're going to need more care. So you have to plan for these things. You want to, when you're investigating your long-term care policies, I've personally looked into different affiliations that I have, whether it's, the state bar or AARP or some other organization that you may belong to might offer coverages that are better than just getting them on the open market. They may be group policies and have more buying power, so they may be less cost. In fact, what you should look at is if you are a member of that association, you personally, your parents may be able to get a policy through you. Like, for instance, I'm a member of the Florida Bar and I think the Federal Bar, and I have a policy that's many, many years old that my parents or I think even my siblings could have gotten as well if they wanted to take on that policy. So you want to look at your own affiliations and their affiliations to see what options are available when you're exploring all these insurances. The last thing I want to talk about briefly, and this is really something that you should see an elder law specialist about, but it's really part of the whole planning process. And what people don't realize is that if you need to plan for Medicaid, you need to plan well in advance. So Medicaid is basically where the government will take over paying for nursing home or potentially home health care when the need arises. The thing with Medicaid is there's a look-back period. They will only cover you if you're indigent. So if you have assets, there's only a certain amount of assets that you and your spouse are able to have in order to qualify for Medicaid. The cost of a nursing home is somewhere between $7,000 and $10,000 potentially a month. That's money that's going to start pouring out of your parents' estate. If you plan ahead with an elder law specialist, then you can potentially structure the assets in such a way where they're gifted out over a period of time and enough in advance before Medicaid is needed. This is a family decision. This should not really be on your parents themselves or on your grandparents, because if they give away their money, then somebody has to take care of them because they won't have any money. So this has to be a full family participation, and there have to be assurances made that they will be taken care of. And they have to trust the fact that you're actually going to take care of them if they're giving you their money well in advance of them needing any sort of nursing home care. But if it's properly done, then it's completely legal and ethical, and ultimately the estate of your parents can be saved because it was given away well before they needed the Medicaid, and then Medicaid can kick in and pay for their care. The Medicaid goes along with all the other documents that we talked about. It's the health care surrogate who potentially has to exercise some of the decision-making power later on with regard to receipts of Medicaid. It's the power of attorney who might have the ability to apply for Medicaid, who also may have the ability to give assets away to the spouse, to the children, to the grandchildren in order to get the parent or grandparent qualified for Medicaid. There's a process. You don't want to wait too long to do it, but you have to plan ahead if you're going to do Medicaid. I'm not an elder law specialist. but you should definitely seek out an elder law specialist to do some planning, and do it before you need it. That way you at least know the facts, because then you can plan ahead to make it work for you and for the family. And it's a really great way, if you can plan ahead, of safeguarding the assets and passing them to the next generation, so that all that the parents and grandparents have worked for is not just spent on a nursing home and pittered away for that. Another thing that you can do, and again, I would consult with an elder law specialist on this, is if you're the one who's handling things for your parents, you may be able to structure a personal service contract where you, as the family caregiver, can actually get paid for doing certain things for the parent or grandparent. The way it works is based on the life expectancy of the person who needs the help. A lump sum payment can be paid to you or whomever is doing this personal service contract. It is income to the recipient, but again, it's a way of gifting, not really gifting, of paying out a part of the person's assets that doesn't have a look back for Medicaid. Because Medicaid is going to look back, I believe it's 5 years for every transfer that was made. They're going to look at basically everything that was removed from the accounts and assets of the person applying for 5 years. So normally you have to plan a full 5 years in advance, but the personal service contract and the payment under that is a way of getting a bulk amount outside of the assets without it being part of that look back period. So again, it's just something that you need to look into because it may be applicable. It's not in every case. The person who's getting the personal service contract can't be doing anything that Medicaid is paying for on a caregiver. So it's kind of stuff that's over and above what's being paid for. You never want to do it on your own. You certainly want to, get proper advice before you do that personal service contract. So just to wrap up, the documents that you need are durable power of attorney, HIPAA release, living will, healthcare surrogate document, declaration of pre-need guardian, potentially a revocable trust. Certainly they should do a last will and testament, but depending on whether or not they do a revocable trust is whether or not the last will and testament is just going to be a supporting document versus the document that gives away everything at death. And then you should be looking at long-term care insurance, maybe whole life insurance with a long-term care rider or the ability to borrow cash. You should be looking at whatever their retirement accounts are. You should be looking at knowing essentially what their assets are and what type of planning they've done. Whether or not you've seen the planning or not, you need to know that they've done it and where they keep it in the event of an emergency. Another thing that you should know, and this came up with a client of mine, is if your parents are getting older and they're starting to decline, you should know what medications they're on and what doctors they see. A real-time story that one of my clients, the parents were elderly and living alone, and the mother was in charge of the father's pills. She basically gave him all of his medications and made sure he got the right ones and they got him at the right time, and she unexpectedly passed away. And no one had any idea what medicines he was supposed to take and when. And it was very scary. And it took a couple of days. They had to have the doctor essentially come to the house, which is almost unheard of, to look at all the medications, and they had to trace out what he was actually taking and when he should be taking it. And it took a couple of days, and it was a little bit scary there. But we don't think about those things. So you make sure that at least if they're not telling you, make sure they have a good list with the medications, when they have to take them, and what they're for, and maybe they put it on the refrigerator so that if somebody has to come in, they'll know what needs to be done and that everything is very clearly labeled. Another thing we didn't really talk about is the DNR, the do not resuscitate. If your parents feel strongly about having a do not resuscitate order, Then what they need to do is they need to have that and put that on their refrigerator in their home. It usually has to be done on a gold or yellow piece of paper, because that is what the EMTs are going to look for if they come in with an ambulance. If they're called, they need to see it on, that's where they're going to look, is they're going to look at it on the refrigerator, because it may be too late. Once they revive, it may not have been what your parents wanted. So if they're going to do it, they need to have that document, and they need to have it properly posted, and they need to tell you, because obviously you need to know if you're with them when this happens. You need to be able to instruct the medical personnel. So finally, to end on the final note, and I teach a class in Florida Atlantic University on wills, trusts, and estates, and I always end my incapacity planning class on "Nothing says I love you like the prepaid funeral." And they laugh, but the truth is, it's definitely true. If you are in a situation where something happens to the parent or grandparent and they pass away, and all of a sudden you have to plan the funeral, pay for the funeral, where they're going to be buried, it's not only just a highly emotional time, it's also a very expensive time. Whereas if they've done all of that planning in advance and you're aware of those plans, it saves a lot of the drama and the trauma of when somebody dies, especially when they die unexpectedly. So it's a good idea to have a family conversation about that and to see if they'd be willing to do it, because that way no one has to come out of pocket. And it's very expensive to bury somebody and to do the funeral. So if you don't have to come out of pocket at the spur of the moment, then it's certainly a very good thing. And, you know, I think it's just really a great gift that a parent or grandparent can do by, you know, putting their money out there and paying for all that stuff in advance and making those decisions. That way that burden is off of you when the time comes. Lastly on that, it's great if you want to put it in your last will and testament, all of your wishes regarding, or their wishes regarding, funeral and burial. But the reality is nobody's looking at that will until after you're buried. So it's better for it to be in a separate document, the deed to the burial plot, the contract for the funeral home, whatever it is, it should be discussed before. If it's in the will, that's fine, but it's probably going to be too late to exercise on those decisions that they've already made if it's only listed in the will. They need to tell you what they've decided. If they've prepaid it, great, you should have the paperwork so it's no issue when the time comes. If they haven't prepaid it, at least have a discussion as to what they would want and what the plan is to actually pay for it. Thank you very much for joining me today. We do webinars every month. We alternate between asset protection and estate planning. Next month's webinar is on asset protection, I believe the pitfalls of asset protection, mistakes that might have been made. We also have a weekly newsletter. If you're not already receiving that newsletter, then please let us know. You can email us at info@assetprotectionattorneys.com. If you have any questions regarding today's webinar, please email us there as well. And if you have a group that is interested in a speaking engagement on asset protection or estate planning, please let us know and we'll certainly see if we can arrange for that to happen. And if you haven't already received our books, please let us know and we'd be happy to send them to you. Thank you very much for joining us today, and we hope to have you again next month. Thank you.